Where does your Second Amendment rights begin and where do they end? Stay tuned. Because leaders refuse to explain how the law actually works, people fill that gap with mythology. They think carrying a gun gives them authority. They think protesting means immunity. They think compliance guarantees safety. None of those things are true. Why don't our governors, our mayors, our cabinet officials stand up and plainly say, your constitutional rights cover this much ground, and after that, criminal law doctrine takes over? People would understand the stakes. They would know where the lines are drawn, and they would know the boundaries of their rights without guessing. Yet, what actually happens? When a person is killed in an encounter with federal agents, the Vice President of the United States, the head of DHS, the head of Border Patrol, they all rush to the microphones and speak in charged conclusions, intent to cause maximum harm, weaponize their vehicle, imminent bodily threat. They speak in conclusions, not in explanations. They speak in outrage, not the law. And that's why I don't understand this. Why don't our leaders explain to us the law? Explain to us. Why don't they make it clear how constitutional protections, common law doctrines, and criminal law intersect to give our citizens guidance and safety without leaving them in the dark? I ask this of every citizen. Make this make sense. Here's the distinction nobody ever bothers to make. The Second Amendment gives you the right to bear arms. It does not give you the right to deploy violence. Those are two different legal ideas, and confusing them is where everything is breaking down. The Constitution protects possession. It protects carrying. It protects the existence of arms in the hands of civilians. It protects the existence and safeguards against concentrated power. What it does not do is hand you the rules of engagement. It does not tell you when you may pull the trigger. That authority comes from somewhere else entirely. Heard of the castle doctrine, self-defense, stand your ground, eminence, proportionality. Those are common law doctrines, older than the Constitution itself, applied to knives, cars, fists, anything capable of force. They govern violence, not ownership. And that matters. Because when the government argues a case involving a firearm, they're often not arguing the Second Amendment. Not at all. They're arguing intent, context, state of mind, whether bearing an arm crossed the line into threatening force. And that's where words like intended to cause maximum harm come from. That's criminal law, not constitutional law. And historically, yes, this country once recognized a right to resist unlawful state force. Early Anglo-American law allowed resistance to illegal arrest. That right didn't disappear because of the Constitution. It disappeared because modern states decided it was too dangerous to allow individuals to adjudicate legitimacy in that moment. That decision may be practical, it may even be necessary, but let's not lie about what it is. We pretend the Second Amendment is just about burglars. We erase history. 2. When we pretend the Second Amendment is just about burglars, we erase history. When we pretend it authorizes violence, we erase law. And when we mash the two together, we leave people confused, armed, and misinformed. Clarity matters. The Second Amendment secures capacity for the civilian to own a firearm. Common law governs the conduct of that use of that firearm. Criminal law enforces the boundaries of the use of that firearm. And responsibility lives in any of the gaps between those three. If we don't teach that honestly, we aren't protecting anyone. We're just handing people half a map and acting surprised when they get lost.